Turning to the elements of aiding and abetting by omission, the appeals chamber considers that the mens rea and actus reus requirements for aiding and abetting by omission are the same as for aiding and abetting by a positive act. Thus, the omission must be directed to assist, encourage, or lend moral support to the perpetration of a crime and have a substantial effect upon the perpetration of the crime, which forms the actus reus. Further, the aider and abetter must know that his omission assists in the commission of the crime of the principal perpetrator and must be aware of the essential elements of the crime which was ultimately committed by the principal, which forms the mens rea. The critical issue to be determined is whether, on the particular facts of a given case, it is established that the failure to discharge a legal duty assisted, encouraged, or lent moral support to the perpetration of the crime and had a substantial effect on it. Further, the appeals chamber considers that aiding and abetting by omission implicitly requires that the accused had the ability to act such that there were means available to the accused to fulfill his duty. With regard to the nature of the duty, the appeals chamber recalls that it has previously recognized that the breach of a duty to act imposed by the laws and customs of war gives rise to individual criminal responsibility. Mr. Šljivančanin's duty to protect the prisoners of war was imposed by the laws and customs of war. I will elaborate more on this point later on when I address the prosecution's second ground of appeal. Thus, the appeals chamber considers that his breach of such duty gives rise to his individual criminal responsibility. Accordingly, Mr. Šljivančanin's second ground of appeal is dismissed in its entirety. In his third ground of appeal, Mr. Šljivančanin argues that the trial chamber erred in finding that Mr. Mrkšić put him in charge of the evacuation of the Vukovar hospital and thereby entrusted him with a legal duty to protect the prisoners of war at Ovčara. The appeals chamber finds that it was reasonably open to the trial chamber to conclude, on the basis of the totality of the evidence before it, that Mr. Šljivančanin was under a duty to protect the prisoners of war from the Vukovar hospital by reason of the responsibility delegated to him by Mr. Mrkšić. Accordingly, Mr. Šljivančanin's third ground of appeal is dismissed in its entirety. In his fourth ground of appeal, Mr. Šljivančanin challenges the trial chamber's finding that he must have witnessed the mistreatment of the POWs in Ovčara. The appeals chamber recalls that, with respect to Mr. Šljivančanin's first ground of appeal, it has found that he failed to demonstrate that the trial chamber committed any error of law or fact with regard to his presence at Ovčara on the afternoon of 20 November 1991 and the timeline of events of that afternoon. Under his fourth ground of appeal, Mr. Šljivančanin does not attempt to further substantiate his arguments under his first ground of appeal. Accordingly, his fourth ground of appeal is dismissed in its entirety. In Mr. Šljivančanin's fifth ground of appeal, he submits that the elements of aiding and abetting the torture of the prisoners of war at Ovčara were not fulfilled. First, with regard to whether Mr. Šljivančanin's failure to act had a substantial effect on the commission of the crimes at Ovčara, the appeals chamber finds that the fact that other officers better placed than him to ensure the protection of the prisoners of war at Ovčara also failed to act does not itself negate the effect of Mr. Šljivančanin's failure to intervene to prevent the mistreatment. As to Mr. Šljivančanin's contention that he was not responsible for the security of the prisoners of war held at Ovčara, and that it has not been proven that he could have prevented the mistreatment of prisoners of war, the appeals chamber recalls that it has upheld the trial chamber's finding that Mr. Mrkšić ordered Mr. Šljivančanin to be in charge of the evacuation and authorized him to use as many military police as necessary to escort the prisoners of war and ensure their safe passage. The appeals chamber finds that Mr. Šljivančanin failed to show any error in the trial chamber's consideration of whether his contribution had a substantial effect on the mistreatment of the prisoners of war at Ovčara. Second, with regard to Mr. Šljivančanin's argument that the trial chamber erred in finding that he must have been aware that his failure to give clear direction to the military police or to reinforce them assisted the commission of the crimes, the appeal chamber considers that, in light of the fact that Mr. Šljivančanin saw the mistreatment of the prisoners of war at Ovčara occurring despite the presence of JNA troops, it must have been clear to him that the JNA officers and troops present were either unable or unwilling to prevent the beatings. Mr. Šljivančanin must have known that it was his responsibility to protect the POWs and that he had the authority to take action. Knowing what he did, the only reasonable conclusion is that he knew that his failure to take any action to protect the POWs assisted in the mistreatment of the POWs by the TOs and paramilitaries. As a result, it was open to the trial chamber to conclude that Mr. Šljivančanin possessed the requisite mens rea for aiding and abetting torture. Accordingly, his fifth ground of appeal is dismissed in its entirety. Mr. Šljivančanin's sixth ground of appeal will be addressed at the end of this summary in the part relevant to sentencing. I now turn to the prosecution's second ground of appeal, which is also relevant to Mr. Šljivančanin. In its second ground of appeal, the prosecution argues that the trial chamber erred in fact and in law in failing to find that Mr. Šljivančanin was responsible for aiding and abetting the murder of the 194 people identified in the schedule to the trial judgment as having been killed at Ovčara on the evening of 21 November 1991. The prosecution submits that the trial chamber erred in failing to find that Mr. Šljivančanin knew at the time of his visit to Ovčara that the TOs and paramilitaries would likely kill the prisoners. With regard to the mens rea of aiding and abetting the murders, the trial chamber found that it was only upon the final withdrawal of the JNA troops from Ovčara on the evening of 20 November 1991 that the killing of the prisoners of war became a likely occurrence, and therefore that it was possible that Mr. Šljivančanin did not foresee the likelihood of the murders prior to learning of the withdrawal. The appeals chamber finds that it was not unreasonable for the trial chamber to have concluded that as long as the presence of the JNA troops continued, they might have continued to provide a sufficient intervening element to prevent the mistreatment by TOs and paramilitaries from escalating from physical abuse to killing, despite their failure to prevent mistreatment altogether. Thus, it was not unreasonable for the trial chamber to conclude that Mr. Šljivančanin could reasonably have believed in the circumstances that the TOs and paramilitaries would be unlikely to resort to killing. As a result, the appeals chamber finds that Mr. Šljivančanin did not possess the requisite mens rea for aiding and abetting murder, as long as he was under the understanding that the JNA troops remained at Ovčara. The appeals chamber notes that the trial chamber did not make a finding or draw any inference as to when or whether Mr. Šljivančanin became aware of the order to withdraw the JNA troops on the night of 20 November 1991. However, the only reasonable conclusion that can be drawn is that Mr. Mrkšić told Mr. Šljivančanin in the course of their meeting upon Mr. Šljivančanin's return to Yugoslav that night that he had withdrawn the JNA protection from the prisoners of war held at Ovčara. Given the trial chamber finding that it was Mr. Šljivančanin's knowledge of the presence of the JNA troops that precluded him from concluding that the killing of the prisoners of war was a likely occurrence, the only reasonable inference is that upon learning of the order to withdraw the troops, Mr. Šljivančanin realized that the killing of the POWs at Ovčara had become a likely occurrence. Similarly, knowing that the killing of POWs was the likely outcome of their being left in the custody of the TOs and paramilitaries, Mr. Šljivančanin must have also realized that given his responsibility for the prisoners of war, if he failed to take action to ensure the continued protection of POWs, he would be assisting the TOs and paramilitaries to carry out the murders. As a result, the appeals chamber finds that upon learning of the order to withdraw the JNA troops from Mr. Mrkšić at their meeting of the night of 20th November 1991, the only reasonable inference is that Mr. Šljivančanin was aware that the TOs and paramilitaries would likely kill the POWs, and that if he failed to act, his omission would assist in the murder of the prisoners. Accordingly, the appeals chamber finds that upon learning of Mr. Mrkšić's order to withdraw the JNA troops from Ovčara, Mr. Šljivančanin formed the mens rea for aiding and abetting murder. Under its second ground of appeal, the prosecution also challenges the trial chamber's finding that Mr. Šljivančanin's legal duty towards the prisoners ended upon the withdrawal of the last JNA troops from Ovčara upon Mr. Mrkšić's orders. Before elaborating on the correctness of this finding, it is pertinent at this juncture to recall that the trial chamber did not make a finding as to whether the armed conflict in the municipality of Vukovar at the material time was of an international or non-international nature.